wanasema hilo linaonyesha hawataweza kupata haki katika kesi hii. Sasa watadhihirisha vipi mahusiano haya? Maanake ulisema mahusiano ni muhimu, mtu anaweza kusema mahusiano haya na ikakubalika kwamba haya mahusiano ni ya karibu sana. Unadhihirisha vipi?
Kudhihirisha ni ushahidi. Unajua, unaposema mtu amenufaika, sasa kunufaika huko kunahusiana vipi?
Has essentially been disabled. Then we have one who is in purgatory, as it were. He is pending. He has been approved by the National Assembly on nomination by the president, but he has not substantially assumed office. Does that not create a political crisis?
This country has once operated without a vice president. There was a time when Moi just let off Saitoti, and then he went again on the street and said, "You people, you think bringing back this guy will bring food on the table?" And then he brought him back. The point I'm making is that there is no crisis. And yes, we can live without a deputy president because there is a constitutional mechanism. If there's a crisis right now, the speaker is next in line. The constitution has various provisions to take care of any crisis. So we shouldn't be worried as to want to do things in a hurry and trample upon a judicial and fair trial and human rights issues.
Are you saying the office of the DP is not a critical office?
Yes, that's what I've said. That it's not a doctor, it's not a medical doctor who is the only surgeon in town that if somebody is in ICU, nothing can happen. As a matter of fact, if they are not there to perform their functions, somebody else in the line can perform that function. So let us not try and imagine a crisis where there's none. Anybody who is trying to argue that we are in a crisis is in a political field, not necessarily a legal field. Because if you asked us now that the president is not there and the deputy is not, what is next? We'll tell you the speaker is next in line. So from a constitutional perspective, no crisis.
All right. So some of the arguments we had yesterday, because there were arguments that there's an attempt to delay the hearing of the matters that were filed as urgent, certified as urgent by the court. And that is 2 applications by the Attorney General, by the National Assembly, that the stay orders in place regarding Kithure Kindiki substantively, or rather being sworn in, need to be lifted. That's the application by the AG, by the National Assembly. And they're saying this should have been disposed of first.
Not at all, not at all. In fact, they are wrong because the moment you have a conservatory order, the court is saying, conserve what is, keep it as it is, as we hear whether or not there's a breach of the law. So that cannot be overridden by some other desire by some people to quickly swear in somebody. What is the hurry? What is the crisis for swearing in somebody who is already a cabinet? In fact, the problem is on the other side. Mm-hmm. The person they want to hurriedly swear has not resigned as a cabinet secretary. Therefore, constitutionally, shouldn't even be sworn in as a deputy president because he does not qualify to be sworn in. So there are issues on that side that if they rush, they will be making the very mistakes. Some of those very issues are being canvassed in court. The issue as to whether there was a properly constituted IBC as to give the advice that is allegedly given is being canvassed in court. So there are more weighty issues to be dispensed with in terms of the nomination of Kithure Kindiki as opposed to when office. So again, what is their crisis? The political crisis has been sorted because the Parliament has done its job. The National Assembly and the Senate have done their political job. What we are dealing with is constitutional and can only be given time. I would tell anybody who is saying, why are you delaying? No. Law operates in a procedural manner. If I bring a case now and somebody raises a preliminary objection, the preliminary objection ought to be dealt with first. In this case, a recusal, application for recusal is a preliminary matter that has to be decided by the very bench that you want to rush to make this other decision that you want them to make in terms of lifting the conservatory orders. So I would say that in matters of law, matters of procedure, we should allow the procedure to play out so that we do not necessarily rush it. You can rush political issues, but please let's not rush judicial legal issues because the consequences, the damage is far-reaching.
So what typically happens when a judge recuses themselves, or a bench, should they recuse themselves in this case?
Beautiful. Again, this is what we are saying, that there's no crisis. If they recuse themselves, then the Chief Justice is presented with an opportunity to again empanel another bench of judges. So, and there are enough judges around in the High Court, so there's no problem so far. And that's why it's not that these judges must hear this case. I would think that even they themselves, if they have no interest, if they have no reason to want to hang around, they themselves should say, look, now that you have raised this matter about our impartiality or lack of impartiality, it's likely that if whatever we render here may not be seen well. So they should actually be the first people to say, wait, we are accusing ourselves. The problem we are dealing with in this country, and perhaps many of the jurisdictions that we have, is that when you are talking about a judge recusing himself or herself, you are actually applying to the very judge, and that the judge can decide whether they can recuse themselves or not. Now, in normal circumstances, what would be the ideal is that the moment I raise an issue about your suitability, it should not be you listening. Somebody else should be listening and making that decision, because I should be making those arguments about you to that person, which could be that I'm actually making, I have evidence that you cannot conceal, and therefore somebody else ought to make that decision. For now, we have a very clumsy situation where I have issues against you, and yet I'm putting to you and asking you to recuse yourself. That is a bit untidy. What is tidier is if, for example, a judge were to come and say, I have an interest in this matter, I would like to recuse myself. Would you, on the other side, argue that, wait a minute, don't? Because no. It would be like, the moment the judge raises the issue, they would recuse themselves and would agree that we move on to the next level.
So in other jurisdictions, is that a matter that is arbitrated, so to speak, by another party?
And procedurally. So, and we see what the ideal issue is that increasingly there are rules of procedure that should allow that to happen. Is it really happening? And again, you saw the other day in the case of Justice Alito in the U.S. Supreme Court. The issue was raised, and the questions again came up. They say, look, how do you then listen to this issue when it's all about you? Again, back to the US, there is need to make sure that these rules actually grow so that judges can also distance themselves when they are accused, because they should not be deciding and trying a matter in which they are the accused. Mm-hmm. Yeah.
All right. So this is a highly politically charged matter. Will that, do you think, weigh into their decision?
I think so. In fact, the worry that I have is whether the judges and the judiciary at this point will act beyond reproach as to want to leave no doubt that they were impartial, they were objective, and whenever their impartiality was called into question, they acted appropriately. I would not entertain drama in a matter like this. These are not the only judges. And by the way, they are very smart judges. All of them. They are good judges. If you look at their history, they have made some very good decisions. I have nothing personal against them. My only issue is, here is a reputation about to be thrown, or some mud about to be thrown at you as a judge. If you have no interest in the matter, or if you have no opinion whatsoever, wouldn't it be your choice to say, wait a minute, now that you've raised this issue, I recuse myself. Can the Chief Justice empanel another one? Of course, it might happen that if at all what they are accusing them is right, it might happen that the next to be appointed may also have issues. Then you will begin to determine, is it really true, or is it just hair splitting? So that should be something else. So my view would be, it should not be something that we should be fighting about. It's like a moment you realize there could be a conflict of interest, the best thing is to do is to down your tools. They say, for example, in matters of jurisdiction, if a court realizes it does not have jurisdiction, it downs its tools, because whatever then it proceeds to do would be questionable. The moment my suitability or my objectivity is challenged, the first thing I should do is to say, wait, I leave it at that point. I don't agree, but I also don't want to give the impression that the decision I'm about to render is likely to be tainted. Mm-hmm. And that's what you want to do in terms of justice. All right. So that's why they say that you should be above Caesar's wife, above reproach.
All right, so I'll be the devil's advocate right after this, because I want us to catch up with Seth Olale. Seth Olale, what is the situation at the Milimani Law Courts at present? And perhaps you can also recap for us what transpired in the morning on the consolidation of cases.
Well, good afternoon, Olive. 3 minutes past, actually 4 minutes past 2:30 p.m. the scheduled time for the afternoon session, which will involve the hearing of a recusal application, or rather petition, by Gachagua's lawyers. This particular hearing expected to be presided over by the 3-judge bench led by Justice Eric Ogola. And what we are seeing right now is a very packed courthouse, of course this being certified as urgent. Have the respondents on this other side of the courtroom, involving the likes of the National Assembly, the Senate, Speaker of the National Assembly, Speaker of the Senate. We also have the Attorney General and of course the interested parties in this particular case, including the Law Society of Kenya. We are still waiting for the judges to make their way. They stated 2:30 p.m. We have also received communication by the clerk of this particular court inviting the council just to submit prior application when in terms of using the city fee system, that is the electronic application. Any matter that is pending, they have been invited to submit before the 3 judges make their way in this particular courtroom. Yesterday we saw also quite an exchange, of course, after that particular that particular ruling regarding the jurisdiction of the Deputy Chief Justice Philomena Mbete Mwilu, whether she acted in law while constituting the 3-judge bench, and of course the court here stating that indeed she was acting according to her rightful mandate and she did not violate any judicial rules. Now the next matter here is the second application from the Rigathi Gachagua, which is a recusal application. They basically want the judges here to excuse themselves